black line. Face the camera. Say your full name.
John Fine Dorsey.
Who?
John Fine Dorsey. I say Walker Dorsey. Yeah.
Oh, Dorsey, I got it.
I don't have that one as of yet. Can we?
This got also Walker, John Dorsey Walker. Walker Dorsey.
Yes,
We don't
sir.
have that.
You don't have that one yet?
Right. Can we do the 2 walk-ins or just while we're waiting?
Okay.
We'll try to find out.
All right.
What's your preference?
No, we do the walk-ins.
Okay.
All right, sir. Just give me a moment. Is that Akili James? All right. And what's your name again, sir?
John Dorsey.
Are you ready on him yet?
Say that again.
Mr. Dorsey,
Dorsey.
the one you said you weren't ready on.
John Dorsey. I am prepared to proceed.
Okay. Okay. Mr. Dorsey, state your name again for the record.
John Dorsey.
All right. This is case number 250-576-3801, Peace and Michigan versus John Dorsey. Appearances, please.
Thank you, Magistrate Stevenson, for the people.
For the record, Christina Harris on behalf of John Dorsey, who stands mute, waits a formal reading of the complaint. Mr. Dorsey has been explained and he understands the statutory and constitutional.
All right, the court and not guilty plea on behalf of your client. Bond recommendation from the people.
Magistrate, the way I read this, it all started as a direct result of apparently the complaining witness, who's the mother of the defendant's child, spilling pot on the bed. So the defendant takes exception to that, chokes her out, hits her. In this particular instance, apparently there was observable injuries. The way it's being charged in the allegations, we're going to be asking for a $25,000, 10%. We're also going to be asking for monitorization here.
Okay. No, hold on. Yeah, I see that, and I see. Let me just put this on the record. The report indicates after spilling the marijuana, the complainant then tripped over an object in the room and grabbed onto the defendant to prevent herself from falling over. Now, that could be, that may very well be true in terms of preventing herself, or she could have been, I guess the defendant could have taken it as an assault on him, given what had just happened. And then it looks like he became upset and according to the report, stated, "Don't grab me," which means that he wasn't aware that, possibly aware that she tripped. And I can understand how, given that situation, he could have felt assaulted, and then he retaliated. And I've said all that to say, Ms. Harris, is that you're kind of, or would you be alluding to a kind of a self-defense claim?
Yes, you are very adept at, we've been working together for a while and understand the way that each other thinks. Yes, you're
Yeah. And I could see why, particularly if he wasn't aware that she fell, that she assaulted him. And for that reason, I'm going to give him the benefit of the doubt in this matter. Ms. Harris, they don't live together, is that correct?
That's correct.
Okay. And like I said, it seems like a mix-up of understanding. I can see how a reasonable person would think being assaulted, if this allegation is true, is like, "Don't grab me." That's clearly an assault, and he responded perhaps aggressively, overly aggressively, assertively. I can see why he, arguably felt the need to defend himself. All that will be flushed out. I am going to give him a $5,000 personal bond in light of that. No contact with the complaining witness. You cannot go back to the Carlisle address. You're not to possess any handguns, firearms, other dangerous weapons, and no marijuana. Probable cause to be May 27th, preliminary examination June 2nd, both in front of Judge Jack Kay. Please step aside, sir.
Thank you, Your Honor.
Oh, I take it, no objection? Okay, all right.
None heard?
Okay.
Yeah,
Do you need a breakout room, Mr. Turner?
please, Your Honor. Thank you so much. Your support.
Okay. All right, Officer Robertson, get ready. Okay, accept the
Can I
invitation.
keep it down?
I'm sorry?
We joining now.
Okay. All right, what's your name, sir?
Joseph Terrell Road.
Can you repeat that?
Joseph Terrell Rhodes.
Terrell Road.
Dope Rose? Okay. All right, this is case number 250-576-2901, Pearson, Michigan versus Joseph Terrell Rhodes. Appearances, please.
Thank you, Steve Benson for the people.
For the record, Christina Harris on behalf of Joseph Terrell Rhodes, who stands mute, waits a formal reading of the complaint, and Mr. Rhodes has been advised of and understands the statutory and constitutional rights.
All right, the court will enter a guilty plea on behalf of Mr. Rhodes. Ma'am, sir, you know the routine. Given the nature of the offense, ties, community, like criminal history, and objection to a $5,000 personal bond for Mr. Rhodes.
None from the people.
Objection.
Okay, Mr. Rhodes, you're given a $5,000 personal bond, sir. While this case is pending, sir, you're not to possess any handguns, firearms, or other dangerous weapons. Probable cause will be May 22nd in front of Judge Kevin Robbins, preliminary examination May 29th in front of Judge Jefferson. Please step aside, sir. Face the camera. Say your full name.
Barry Boris Thompson.
Barry Thompson.
Barry Boris Thompson.
Okay, give me one moment, sir. All right, this is case number. Let me get it together here. This is case number 250-57643, Pearson, Michigan versus Barry Horace Thompson. Appearances, please.
Thank you, Magistrate Stevenson for the people.
For the record, Christina Harris on behalf of Barry Horace Thompson, who stands mute, waits a formal reading of the complaint, and Mr. Thompson has been advised of and understands the statutory and constitutional rights.
All right, the court will not guilty plea on behalf of Mr. Thompson. Mr. Vincent, you asking for a remand in this matter?
I am, Magistrate, and really briefly, yeah, just a couple of administrative things. One, the defendant previously, he was convicted of stalking out of Macomb. He just had an AWIM case out of Judge Cox's courtroom dismissed. That was an AWIM as well as an assault with intent to rob while armed. Magistrate, for all intent and purposes, this is about as cold-blooded as you can get. Have allegedly the defendant crossing the street with multiple witnesses who see him with a mask on, approaches the victim who's with his mother, only to shoot the victim because he's dead, only to shoot him in the head. And then the defendant flees. And he's been ID'd as the shooter. So respectfully, I don't need to go on. We're asking for a remand.
Okay, Ms. Harris, your response?
Yes, your response is there are allegations, and despite the fact that allegations may seem quite egregious or heinous, they are allegations, and Mr. Thompson is innocent unless proven guilty beyond a reasonable doubt. Mr. Thompson is the life resident of this area. He works at a large hacking company as a quality inspector. Counsel talked about dismissed charges. And I don't think dismissed charges should be held against someone and.
No, because they're not convictions, so I'm not considering them at all.
Thank you. Thank you
Yeah.
very much. Thank you very much. And so, but he did indicate that the assailant in this matter was wearing a mask. And so I consider maybe someone wearing a mask and being later identified, that identification could possibly be dubious. And for that reason, the charges are homicide first degree and felony firearm. We're asking for a cash bond and not a remand.
Magistrate, just so I,
Briefly, yeah.
no, it will be, just so I can address this. That was a summation. I could get into the exhaustive investigation about how this defendant was found in the car and then ID'd. I mean, the mask is only one part of it.
I'm well aware of that.
Okay.
And you know, I'm well aware of that. But looking at the totality of the circumstances, the facts of this case, I believe under MCR 6.106, that the presumption of guilt is great in this. And therefore, I will remand Mr. Thompson in the custody of the Wayne County Jail while this case is pending. Probable cause will be May 27th, preliminary examination June 3rd, both in front of Judge Jacquet. And to your point, Mr. Vincent, I can go on, I wouldn't say ad nauseum, but there is a great deal of evidence in terms of with respect to identification, so on and so forth, that made this court conclude that the presumption of guilt is a presumption of guilt in this matter that qualifies for remand under MCR 6.106, and I will remand him accordingly. Probable cause May 27th, preliminary examination June 3rd. Step aside, Mr. Thompson. Are you finished, Mr. Reagan?
What? Yeah.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.